Good morning, Athena.
Good morning. How can I help with EU law today?
Do you have a problem if I record this discussion?
Thanks for asking. I don't mind being recorded. Two quick notes. For your privacy and others, avoid sharing sensitive personal data while recording. If you plan to share the recording publicly, check local consent laws. In the EU, some countries require all parties to agree.
It will only be for education purposes, actually, for my students.
That's fine with me. A couple of gentle reminders for an educational recording. Get consent from anyone whose voice might be captured. Avoid naming identifiable individuals or sharing sensitive data. If you include excerpts, cite sources, and show dates so students see context. Store the file securely and set clear access limits for your class. Ready when you are. What EU topic shall we tackle?
Thank you. We shall discuss together, actually, today. Can I ask you a question about the primacy of EU law vis-à-vis domestic laws of the EU member states?
Great topic. Here's the essentials, with history, today's practice, and points to debate. Core idea. Primacy means EU law takes precedence over conflicting national law, whatever its rank, including constitutions. Key cases and evolution. Costa v. ENEL 1964, EU created a new legal order, member states limited their sovereignty. EU law prevails over later national statutes.
Okay.
Inter-
Can I ask more in particular, uh, what is the situation when we have a constitutional provision of an EU member state which conflicts with a provision of EU law? What is the situation there, actually?
Short answer. In EU law, the EU rule prevails. The national authority, court or administration, must set aside the conflicting constitutional provision for that case. In national law, some constitutional courts accept this in practice, but many add conditions or red lines. Key EU law position. Costa v. ENEL, 1964 primacy over later national law. Internationale Handelsgesellschaft, 1970 primacy even over constitutional norms. Cementhal, 1978 every national court must disapply the conflicting national rule immediately, without waiting for repeal.
Thank you. Thank you. Now, in practice, what happens actually? How the European legal order treats older constitutions of member states who founded the European Economic Community.
Clear, practical picture. EU law stance. The EU treats all member state constitutions with respect, but requires disapplication where they conflict with EU law in a given case. No constitution is repealed. Instead, the conflicting clause is set aside case by national bodies. How this works day to day. National courts, after Cementhal, any court must ignore a conflicting constitutional rule for that dispute and apply EU law. Administrations must also prefer EU law when acting, e.g., granting licenses, taxes, procurement. Constitutional amendment. Many states have added EU clauses to their constitutions to accommodate primacy and transfer of powers. Dialogue, not blind obedience. Preliminary references. Courts ask the CJEU for guidance, keeping a judicial dialogue rather than a clash. Constitutional red lines. Some courts accept primacy but reserve control in exceptional areas. Identity, ultra vires, rights. Germany, Solange/2, Maastricht, Lisbon, PSPP, ultra vires/identity review.
Especially
Italy.
with Germany, thank you. Especially with Germany. Do you know of a recent case law which the German Constitutional Court disregarded actually?
Yes. The PSPP judgment of the German Federal Constitutional Court in May 2020. What it was about. The ECB's public sector purchase program, a bond buying scheme. The CJEU had earlier upheld it as compatible with EU law. What Karlsruhe did. It declared the CJEU's judgment ultra vires for being manifestly methodologically flawed. It held that German authorities and courts must not apply the CJEU's ruling unless the ECB gave a proportionality justification within a set time. It threatened to bar the Bundesbank from participating in the program. Why it matters. First time a national court openly refused to follow a CJEU judgment in an EU core competence area. It tests the limits of primacy and the duty of loyal cooperation. After exchanges, the ECB and Bundesbank provided extra reasoning, and the immediate conflict de-escalated. Think critically. Does identity or ultra vires review safeguard democracy at home, or does it fragment the EU legal order? If every court could do this, how would uniformity of EU law survive? Where is the line?
Thank you so much. You have been really helpful with your remarks and your replies, which was very accurate and fast. Yesterday, you were not available, unfortunately. We had a reunion of class 1985 of students, graduates actually, of the Faculty of Law of the University of Thessaloniki. But today I will show them this video and I think that they will be happy.
That sounds wonderful. I'm glad today's session helped. If you share this with your 1985 Thessaloniki classmates, here are 2 quick prompts to spark discussion. Is the PSPP judgment a healthy constitutional safeguard or a threat to EU legal unity? Should constitutional identity limits be defined at EU level or only nationally? If you want, I can prepare a 1-page handout with key cases and questions for your group.
I will ask them. Thank you so much for your conversation. Bye-bye.
Bye. Thanks for the great discussion. If you need a handout or a quick quiz for your students, just ask. Have a great day.